Yeah, good evening. My name's Nicholas Wansbutter. I'm a lawyer in Stratford, Ontario, Canada, and welcome to Don't Talk TV. So I see we've got 7 viewers, so that's good to start. Just had another long day in court here, so let's get it started. Now, I had a couple topics in mind to start off with, but please hit me with your questions and see if we can get a bit of a conversation going. So, kind of one of the burning things that's on my mind and that I've seen a lot of lately is all this. It's been going on for years. It's been going on since the 90s, but it's been really ramping up recently. Is a lot of this diversity, equity, inclusivity stuff, and this whole white people, especially white men, need not apply. I'll just throw a couple links in the in the comment section here. I've got a Twitter or X post from a channel that's called End Wokeness. So they've got here a Government of Canada website, a screenshot from the Government of Canada website talking about summer employers discriminating and being encouraged to discriminate against white people, white young people, and not give them jobs. So those of you you can click the link. I'm just going to read off it here. It says, opportunities for youth that are underrepresented in the labor market, including Black and other racialized youth, Indigenous youth, and 2 SLGBTQI plus youth. Just first off the hop, I'd like to see the evidence or the data that says these people are underrepresented in the labor market proportional to their population. I highly doubt that they're actually underrepresented, but that's not the real question. The legal question that people bring up to me, well, let me just read this a bit more. It says, the purpose of this priority is to provide opportunities for youth that are underrepresented, particularly Black and other racialized youth, etc. So it's a priority. They're given priority over white people. I've been asked by a few people, is that legal? Short answer is no, it's completely not legal. Human Rights Code of Canada, Human Rights Code of Ontario, and Human Rights Codes of all the various provinces are all crystal clear that you cannot discriminate on the basis of race. So the law as written, completely illegal. Now, the law as applied in real life, frankly, my knowledge and fortunately, I don't have any firsthand experience with our human rights tribunals, but from what I know of them, first of all, it would take you 5 years to even get to court. And secondly, if you brought a claim as a white person, I think more likely than not, you'd be laughed out of court. So yeah, yes, it's illegal, but this is like COVID stuff, right? There was so much illegal stuff that went on, especially the vaccine mandate. And just that's the first thing off the top of my head. Look at episode 51. I show all the law there, crystal clear that was illegal. All the legal experts on TV were saying that it's illegal and this is a crazy conspiracy theory for anyone to say that there's going to be a mandate right up until August the 13th of, 2021? And then all of a sudden now, oh, no, it's legal. No, there's always that, what's the law on paper, but then what's the reality on the ground? So, that's, and I've experienced, I'm not going to, it's not worth my time to, I actually did this as a social experiment, but I did actually apply for my old job as a Crown attorney. I'm just going to post the link to a very similar position. This one's in Thompson. The one I applied to was in, it's saying that's the link is too big to allow me to share it. Let me see if I can get it right off of the Government of website. Well, let me just read it to you anyway. You can look it up. You can do a Google search for Crown Attorney Jobs, Manitoba Government. There's one in Thompson right now. I applied for exact same position in Winnipeg and in Portage la Prairie about, I think it was back in January. So it says on the ad here, employment equity is a factor in selection for this competition. Consideration will be given to women, Indigenous people, visible minorities, and persons with disabilities. Well, I'm none of those things. I'm a white man. I'm a white straight man. I mean, I have a wife and children. You know, I did this job for 4 years. I now have more than 15 years of experience in Ontario as a defense lawyer. I didn't even get an interview. So, I mean, that shows you how these things operate. And so, I'm not going to bother bringing a human rights complaint. I just did it more of as a social experiment to see whether I could prove myself wrong. People would say, "Oh, you're exaggerating. You're just pessimistic. It's not really that bad." Well, it is. That's how these things play out. It's not just priority. It's you're a white man, don't apply. And as I say, this has been going on for years. I know my volunteer PR guy, Richard, is in the chat here somewhere. Richard, if you can dig up that link for that ad from the 90s, I think it was the RCMP where they're saying white people don't apply. If you could throw that in the chat, that would be excellent, because I don't have that one close to hand. But while we're talking about employment stuff, and Linda Shaw, I see your question. I'm going to get it to in a minute, but since I'm on a roll here with the employment stuff, I'm just going to throw this other link here. Great example of Danielle Smith being a great, true conservative. She's, in addition to launching an Alberta provincial police force to replace the RCMP, she has instituted this permanent residency pathway for police officers. So that means that they're looking to recruit, attract people who have no legal status in this country. They're not citizens, they're not landed immigrants, they're not permanent residents. They're just people that want to live in Canada, work visa. Then now they're going to be policing our population. That's a pathway to citizenship for them, or a pathway to permanent residency, not even citizenship. To me, I think that's crazy to have non-citizens being police officers. You should at least be a permanent resident, have some sort of connection to the country, some sort of long-term connection to the country to be policing other members of the country. And it's not like there's any shortage of people, but we know what the shortage is. I mean, let's be honest here. There's no shortage of young white men applying to be police officers. They obviously have a shortage of non-white people, so now they need to go outside the country to find them. So, I mean, it's legal because they can make it law. They can just change the law and say you don't need to be a citizen to be a police officer. So before I start getting into a couple questions I've got here, it's been pointed out to me that people don't think that I wear real bow ties, which, frankly, I find that a little bit offensive, that people think I would wear a clip-on bow tie. But just to prove that, and because this is a casual chat, you can already see I don't have a jacket on, let me take off my bow tie here and show you that this is not a clip-on or fake bow tie. So as you can see, look, not a fake, not a clip-on bow tie. I actually do know how to tie bow ties. I mean, clip-on ties, it's like clip-on suspenders. I don't wear clip-on suspenders either. I have buttons sewn into my pants. Well, the pants I'm wearing today, the suit I'm wearing today does not have suspender buttons sewn into them, so I'm not wearing suspenders today. But there you go. There's the proof. It's a real bow tie. They're all real bow ties. So let me see here. Linda Shaw posted the first question. She said, so with no new sticker thing in Ontario, what happens if we drive to Quebec or another province? Will they be aware of Ontario's rule? Well, I only practice law in Ontario. I don't know what other provinces do, but I assume that they would know that, because most vehicles wouldn't even have a sticker. So even if you have an outdated sticker, I really don't know what sort of information is shared between police forces. I haven't traveled outside the province, so I guess I'll have to see how that plays out. So, CP has asked why bow ties. I guess my question would be why not bow ties, but why bow ties? Because they look fantastic. they're classy, and I have good fashion sense. So that's why I wear bow ties. I mean, there's nothing wrong with regular ties too. I have to wear ties in court, so why not have some variety? I nothing wrong with wearing regular ties all the time if that's what you like. Personally, I just like both. I like how bow ties look. I like how whatever you'd call regular ties. So I wear both. I like to wear bow ties. I tend to wear bow ties a little bit more often, again, just because I think they look nicer, they look snappier, and no one else wears them, so it's become a bit of a trademark. So again, my PR guy Richard, he could tell you all about PRing and why it's good to have something unique like that. Although it didn't start out as, oh, I want to be unique, I want to have a bow tie to be unique. It just started like, hey, these things look awesome. They need to make a comeback, so I'm going to start wearing them. Similar to why I wear hats. You don't see them on the show because I'm always indoors, but I think hats look fantastic. They need to make a comeback, so I started wearing them. And they offer crucial protection. I mean, you can see how much hair I have on the top of my head. I need something to keep the sun off that head, because it's painful to walk around in the summer without something covering my head. And in the winter, it's painfully cold to not have something covering my head. So I wear hats when I can. Now, hats are harder to find than bow ties, actually. So in the summer, I'm in tough a bit because I can't find a decent straw hat. I've had a couple, but straw hats don't last as long as felt hats. So I'm kind of between straw hats right now for the summer. I had a fantastic one from the Biltmore Hat Factory in Guelph, but that place closed down over 10 years ago. And I'm still kicking myself. I was in Ecuador. Oh man, how many years ago was that now? That was probably close to 10 years ago too. And I foolishly didn't buy a Panama hat while I was there because I was traveling light. I just traveled with my carry-on bag, and I figured, how am I going to transport this back? Well, if I was smart, I would have thrown the hat I was wearing in the garbage and worn a Panama hat back, because they're only $50 in Ecuador. They're about $300 plus here in North America. So so I just noticed one of the questions here from Bulmus Piper. Is that your real hair? Yeah, what hair there is, it's real. And I can tell you it's real because I would have no problem being completely bald if I was completely bald. In fact, my lack of baldness and lack of gray hair is a source of consternation and frustration to me, because in my line of work, male pattern baldness and gray hair, they help as a lawyer. I've actually lost clients because people say, you look too young, you can't be that experienced. Well, that hasn't happened recently, so I guess I'm starting to look a little bit older now that I'm in my mid-40s. But back when I was in my 30s, people would say you don't look old enough. So hopefully I'll get some gray hair and get that distinguished lawyer look. So Kenny Gilman has asked if I have thoughts on the dramatically lower sentences criminals are getting now versus a generation ago. And will criminals who served long sentences in the past sue for restitution in the future? Well, I actually I'm not entirely sure that sentences are dramatically lower than they were a generation ago. Now, of course, I didn't practice law a generation ago. A generation ago, I was a child and not aware. I haven't done any in-depth analysis into what sentences used to be, because of course sentences from the 60s and 70s are not particularly useful precedents in dealing with sentences in the court today. But sentences have always been light in Canada. I think light relative to the United States. I think that the reason they appear to be light is because of the perception, because there's so much more media, there's social media, things get shared around all the time. Because I see people posting things on the internet all the time, they're outraged, absolutely outraged over sentences. I'm sitting there thinking, well, people have been getting this type of sentence for this type of crime my whole career, but there hasn't been that public awareness. Then there are things where the sentences are going up dramatically. And I've talked about this, Richard, I'm going to ask you to help me out in the comments box here. with what episode number it is, because I'm sure you'd rather me looking at the screen talking to you rather than flipping through another screen looking for the episode number. But I looked at, what sort of sentences do people get for armed robbery, for child trafficking, or for possession of child pornography, and what type of sentences do people get for thought crime. I mean, really, that's what it is at the end of the day. The hate crimes, it's thought crime, or it's being rude crime, or spreading things that other people don't like. I mean, it's not actually physically assaulting anyone. It's, maybe you could say it's, I don't believe that words are violence. Words are words. Okay, thanks, Richard. Episode 205, check that out. I do a bit of a survey of some sentencings. I know some of those sentencings I looked back, for sure with armed robbery, some of them went back as far as the 80s, some of the cases I looked at. So I think armed robbery has been, kind of the sentences that I talk about in episode 205 for many, many years. Now, of course, hate crimes didn't even exist more than 20 years ago. Questioning any aspect of the Holocaust, that wasn't a crime until the last, I think it was a year or 2 years ago, when the Conservative Party of Canada introduced that as a private member's bill. But I mean, people are getting hammered with that stuff. Again, look at 205, and I know I've done another one, Richard, I know you'll throw it up there as well. Where people are getting 15 months, 2 years for making memes. Making articles where they talk about, they say certain groups have influence in banking or in media. That can land you in jail for 2 years. But also doing an armed robbery can land you in jail for something similar. So look at episodes 204 and 205 for some information on that. But yes, CP, you're mentioning that you're shocked to learn about the light sentences in Canada. I think it's something that hasn't gotten a lot of attention. They talk about a lot in the US, and then that makes it even more shocking. Because I remember when I was a prosecutor in Manitoba, so that was the early 2000s, and I remember I remember there was a case, I can't remember what type of case it was, but something really bad, like child trafficking, or yes, it was a sexual assault of a minor. And there was a case that happened in Winnipeg and a case that happened in Minnesota within days of each other. And the sentence in Minnesota was 10 times the sentence that the person got in Canada. I can't remember what exactly the sentences were. I just remember specifically that the person in Minnesota got 10 times the sentence that the person in Canada got. So, say it was 2 years that the person in Canada got, maybe it was 3 years. The person in Minnesota, for doing almost exactly the same thing, got 30. So Linda Shaw's got another good question here. If one stopped a ride program or any traffic stop, is it okay to record the conversation with the police officers? Absolutely. And we've covered this, and I know Richard will put it into the comments box, so keep an eye open for that. We did an episode quite a ways back, near the beginning of Don't Talk TV, specifically addressing the question of can you record police? And short answer, yes, you can. Long answer, episode 17. Richard just put that up there. So for more detail, have a watch of episode 17 where I go over the law and lay out and discuss the reasons why. But again, short answer, yeah, you can record the police whenever you want, and especially when you're in your own car, because it's your own car. They don't have any privacy interest whatsoever when you are in your own motor vehicle and they're speaking to you. So you certainly can. Now, is that always a good idea? I mean, that's your own judgment depending on the particular circumstances. Although, I mean, if a police officer is being very officious with you, or maybe being aggressive with you, then that's probably even more that you want to record that, because you want to have a record of what's going on. It depends on the situation. As a general just to give you another example, as a general principle, I would say don't talk to police. Now, there are some circumstances where I myself have talked to police. So when I was pulled over. I was pulled over recently. I generally get pulled over maybe once every 10, 15 years. I try to drive safely. But when I've been pulled over, I think I've been pulled over 3 times in the entire time I've had a driver's license. I talk to the police. I have absolutely no legal obligation to talk to the police, but in those circumstances where I know they're going to run me, they're going to see that I have a clean record. And, I'm just, every time it's been for speeding, like just a bit over, 10, 15 over the limit. And it's always on long weekends when they're out and they're pulling over everyone who's going a bit over the limit. Well, you talk to them, you say, yeah, I know I was speeding. Your chances of getting off with a warning are higher. Actually, I remember my children said to me, Dad, you always say don't talk to the police. Why are you talking? I said, well, I have no intention of fighting this. So I might as well talk and see if I can have a chance at getting a warning by just being polite and friendly to the officer, which does work. And I don't think there's anything improper about that. I mean, the police have the discretion. I think they should have the discretion to give some people a break. Who would you rather them give a break to? I mean, it should be the people who, and they can see who's a taxpayer. They know, they can, they do profiling. They're not supposed to, but they do profiling. So, they're going to see, okay, there's some middle-aged guy with a bunch of kids in the driving a minivan. Obviously this guy pays taxes. He's generally a law-abiding citizen. We can see his record's clean. So, okay, we'll give him a bit of a break. I mean, he hasn't even been pulled over for 10 years. So, I don't know, Richard, if you're trying to be funny or what they're saying that I had so much more hair in episode 17. Maybe I just didn't have a fresh haircut, whereas today I had a haircut just a couple days ago. But I think my hair's been pretty much exactly the same over the last couple years. Maybe it's receded ever so slightly. But, yeah, just on the topic, I mean, the whole ride program thing, I did cover this recently. I guess it was just the last episode, 209, where he talked about Waterloo Regional Police jumping on this bandwagon of just making everyone provide an approved screening device sample when they pull them over. I think that's illegal. Now, on paper, I mean, that is in the laws I described in that episode. It's been in the law for years. This is part of a bit of a quid pro quo to get Mothers Against Drunk Driving not to rip the government apart for decriminalizing cannabis, that they would institute harsher and more draconian and more totalitarian impaired driving laws. I mean, that's how they phrase it. I mean, this isn't even impaired driving law. This is, to me, this is just harassment of honest citizens as they're trying to go about their business law. But it's, under the cloak of we're going to stop drunk driving. I mean, if you can't tell, if you need to breathalyze every single person you meet, they're not drunk because you're not able to tell that they're drunk. I mean, if you need to do it random, well, we'll see how many people they actually catch doing those things. I mean, and are these people that they wouldn't have caught anyway? I highly doubt it. But we'll see. I'm looking forward to challenging one of those in court, because when I first heard about this law, I said that's crazy. The Supreme Court has been quite clear that the old ASD laws were on the edge. They were a little bit borderline whether they're legal, but at the end of the day, the court says, well, we're going to let it pass because there at least has to be this reasonable suspicion that the person's been drinking. So it's not totally random. It's not arbitrary. It's very brief interruption with people's lives. I mean, I think ride programs are highly problematic, but unfortunately the courts have signed off those many years ago. I'm not a huge fan of checkpoints like that. I mean, checkpoints, like say there's a manhunt, you're looking for some criminal on the run. Okay, I mean, because that's a specific situation where you're looking for something specific. It's not a generalized, we're stopping every single person on the street and we're going to shake them down. It's just for no reason, just because we can, because we're the government. But Linda Shaw is asking a question about whether I'm aware of the Helen Grus case, the Helen Grus case. I am not. I'm not aware of that case at all. So if you could share a bit of information on that, probably won't be able to comment on it because you're only gonna be able to post so much in the chat box. I'm only gonna be able to read so quickly in the chat box. So I wouldn't be able to give a fully informed decision. But thinking of cases that are on the go, I know the situation with the people in Coots is ongoing. I haven't had time to. I haven't had time to follow that, but okay, before I go into that, I was seeing we have another question from Christian Ben. Can they breathalyze everyone in a ride program? Absolutely. They can, as the law is written. I think it's unconstitutional, and I think it'll be struck down, but that's what they're talking about, not just ride program. Everyone they pull over, they're going to be breathalyzing. But under a ride program, previously the law was you could only breathalyze someone if you had a reasonable suspicion that they had alcohol in their body. Now they just, if you're driving a motor vehicle, the police can breathalyze you. So at a ride program, presumably what they're planning on doing now is they'll breathalyze every single person that pulls in there. So there's a person, Running Man, asking whether I'm a real lawyer or a scammer. Well, I'm a real lawyer. Go onto Law Society of Ontario website. You can search my name. You'll see that I'm a lawyer in good standing. So just going back to the Coots situation, I know Rebel News recently released apparently the entire video footage of an interview of one of these individuals. And there's one portion of the interview where the person asked to speak to a lawyer again, and the police officer contacted the lawyer and then went back to him and said, well, your lawyer has no new advice for you. That's a clear violation of Section 10B of the Charter, which gives you the right to retain and instruct counsel. So the case law talks about that is a multi-part test for the police. They have to inform you of the right to counsel, and then they have to implement your ability to speak to counsel. That's for you to speak to counsel. The police don't get to decide whether the lawyer has more advice to give you. Now, maybe I don't know. I don't know why a lawyer would do this. Maybe the lawyer actually said to police, I'm not talking to him, tell him to go away. In which case, it's not the police's violation of his rights. That lawyer has decided not to speak to that person for whatever reason. Now, then they'd have the right to ask to speak to another lawyer, and they could keep asking to speak to other lawyers until they're able to speak to a lawyer and get some advice. So that seems to be a clear violation. I'm not sure how Rebel News was able to get a hold of that video and publish it. Maybe they did that through a Freedom of Information Act, because generally legal counsel, we're, at least in Ontario, maybe they don't do this in Alberta, but in Ontario, we have to give an undertaking. Anytime we receive disclosure, we have to give an undertaking that disclosure will not leave our possession. So any disclosure I have, I can show it to my clients. They can come to my office anytime they want, and I'll set them up with a laptop, and they can view their disclosure to their heart's content. But I'm not allowed to let them leave my office with their own copy of disclosure. So if that's the same in Alberta, I don't know how Rebel News was able to get that, but now that said, it being a clear violation of right to counsel, what's the remedy? That's always the question. The remedy in a situation like that, where you have a violation of right to counsel, is generally exclusion of the statement. You're not going to get your entire case thrown out because the police didn't let you speak to the lawyer. It's the principle is that the remedy for any charter breach has to be connected to that breach in some way. So evidence that is collected as a result of a breach is what's excluded. So in a denial of right to counsel, generally the evidence that's collected subsequent to that or as a result of that breach will be a statement. If if an invalid warrant is issued, or the police do a search without a warrant and it's deemed that they don't have the grounds for a warrantless search, then, well, anything that they found as a result of a search would be excluded. The judicial stay of proceedings, where a case is just thrown out because someone's rights are violated, is reserved only for the most egregious and serious violations, what the Supreme Court calls the clearest of cases. So those are only in cases where something truly exceptional and something that would shock the conscience of the community is some of the wording they use. So if the police really laid a beating on someone, and it has to be a serious beating, because I've seen a number of cases, I've attempted a number of excessive use of force cases, and generally you're not able to get, now I haven't had any ones where people are hospitalized, but basically in my experience, if you're not hospitalized, you're not going to get your charges stayed. And it's also going to depend on what you were doing, why they applied that level of force. But so the Helen Grus case, yeah, now that you're describing it, Linda, about the Ottawa police officer, I think she might have even been a detective who was doing some investigation into sudden infant deaths during COVID, has now been charged. I remember hearing about the case, but I can't remember enough of it right now to make any commentary that would be informed. So unfortunately, I'm going to have to take a pass on that one for now. But that would be I think that would be a good topic to look into it some more, and maybe do a regular episode on that. So Terry Hamlin, thank you very much for the comment and the support, and I'm glad that you found it beneficial to help me understand the law and what's happening in our country. I mean, that's the whole point of this channel. I never wanted to be a COVID lawyer or the COVID lawyer. I mean, I started my channel during COVID. I've been thinking about it for years, but that was what really pushed me. Like, okay, I've got to do this now, because people need to understand the law, be a bit empowered to try to do what they can. Now, the frustrating thing is that the rule of law, and I've talked about this in previous episodes as well, is the rule of law is broken down so much in Canada since March of 2020. And as a lawyer, that's really distressing, because I should be able to tell you this is the law, and you can have a firm and optimistic expectation that that's the way the law is going to be applied, and that things that are clearly illegal aren't going to happen. But the landscape has changed a lot since March of 2020. And thank you, Richard, again, is on the ball with the episode numbers. That's episode 27. So again, we're going back ways. We're on episode 210. Episode 27, I talked about the rule of law and the importance of it, and a little bit on how it's been eroded. And I mean, that's such a huge problem, because when the rule of law starts breaking down, people are going to start losing their trust in the justice system. And when you don't have the trust in the justice system, that is a quick path to anarchy, because eventually they don't respect the law. Certain people are going to figure out that, hey, I get to benefit from Canada's race-based sentencing laws. Maybe what's the point in following the law? I know I'm going to get an extra light touch. And again, race-based sentencing, that's another thing I've talked about. Now, some people might take umbrage at me using that terminology and say, oh, that's white supremacist talk, to be saying there's race-based sentencing. But what else can you call it when the criminal code specifically and explicitly states that people of, well, specifically Indigenous background is what's said in the code, but courts have interpreted this to include other, quote, racialized, unquote, groups, that they're to have a different consideration, different approach to sentencing. They're supposed to be treated differently. That is race-based sentencing. Now, some people, obviously, there's people that think that's a good thing. I'm personally of the view, and I've literally been called a racist in court on one occasion for saying that I'm of the view that everyone should be equal under the law. Everyone should be treated equally under the law. Justice should be truly blind. in the 2020s, that's racism. When I was younger, that was considered just, when I grew up in the 80s and 90s, saying everyone should be treated the same, that was the opposite of racism. But so one person's objecting to the fact that people can't get their own disclosure. How is that legal? Well, I mean, it's legal because you're entitled to be able to see your disclosure. Doesn't mean you're entitled to possess it. And I mean, yeah, you could fire your lawyer and get your own disclosure, and that's what I've even recommended to people. Sometimes when they first meet me, they'll say, well, I want my own copy of my disclosure. I'll say, well, the only way you can get a copy of your own copy of disclosure is if you're self-represented. So you can be self-represented for a while, get your disclosure, review it, and then you can decide whether you want to hire a lawyer. Now, I'm not aware of anyone who's ever seriously challenged that in court, the not having their own copy, but I imagine the court would say, well, that's what you have a lawyer for. If you don't trust your lawyer to be able to let you review the disclosure, then you need a new lawyer. Or again, just be self-represented, because if you don't trust your lawyer to give you access, or if your lawyer isn't giving you access to disclosure, why then, that's the real problem, not the lack of you having your own copy on your own hard drive. And then I think it's mostly a security issue, right? Because let me be frank, a lot of people in the criminal justice system are maybe not the most responsible with where and how they keep things. And I know there's been complaints of massive amounts of disclosure being found in various locations, in the garbage, on the side of the road, in other people's houses. And that's a problem too, because there's privacy concerns. I mean, the accused person themselves is having their privacy. The whole world can now see their disclosure if they leave it laying on the side of the road. And yes, I have seen that happen. And I would think that if you were ever the victim of a crime, you would probably not be too happy if all of a sudden your statement to police showed up on YouTube, or someone left it laying somewhere and all kinds of people were watching that. So I think that's the balance that the courts have. And then, as you always have the right to represent yourself if you don't like that. So that's I think that's completely that's the way to go. If you really don't like the idea of only your lawyer having possession of it, don't have a lawyer. So Canadian Michael has asked, what are my thoughts on the Crown practice of limiting legal aid access by keeping accused persons out on bail and not asking for jail time, thus excluding them from obtaining legal aid? I'm not sure that that's actually a Crown practice. Quite frankly, in my experience has been that Crown attorneys will frequently screen things for jail, even though they don't actually intend to ask for jail, to assist someone in getting legal aid. And then when they actually meet with a lawyer, then it's pretty easy to negotiate a non-jail sentence. So I've seen, in my practice, in my years, I've seen no evidence of police or of the Crown purposely screening things for non-jail in order to deny people legal aid. Now, that's, I think, a whole other question is, what are my thoughts on legal aid being income-based and whether you get jail-based? Personally, I think if you want, purely from an efficiency perspective, in my view, everyone who wants a lawyer should get a lawyer, period. Like, there's no financial test, there's no jail or not jail, it's automatic. Everyone gets a lawyer if they want one. Now, if you really don't want a lawyer, that's your right. You can represent yourself, but if you want a lawyer, you get one, no questions asked. I think that would be more fair. I think it would be more equitable, and if the efficiencies that, people would say, oh, you're going to spend so much money paying lawyers if you give everyone legal aid. You'd save so much money in the efficiencies that it would pay for itself very quickly, because lawyers they do it for a living. We know how the system works. We know where to go, when to go, how to do everything. It goes way faster when you have people in court that just know all these things. So, I mean, that's my personal view. Obviously, that's not shared by many. But to me, that's just fair. I mean, the state automatically has its lawyer. The state, like, it's just such an imbalance of power. So, Kathy Sharp is asking, why do we have sentences based on precedence? Shouldn't each trial be based on unique evidence and be judged? Okay, well, you're talking about sentence and guilt and not guilt. Juries don't judge what your sentence should be. Juries judge whether you're guilty or not. And each trial, whether you're guilty or not guilty, is judged on the evidence of the unique circumstances. Now, if you get to the sentencing stage, every sentence is still unique, but those sentences are informed by prior cases, because it's a principle written into the criminal code, that it's a principle of sentencing in Canada that similar offenders who've committed crimes in similar crimes in similar circumstances should receive similar sentences. To me, that makes logical sense, that if there's something comparable, you should get a similar sentence. Now, it doesn't mean people get an identical sentence, because every case is unique. But looking at prior cases, I mean, it's only fair that if two people with similar backgrounds commit almost the identical crime, it makes sense that they should get the same sentence. That's not fair. That's not equitable that one person would get one sentence, one person get a totally different sentence, just because they got a different judge in a different place on a different day. So that's the principle at play there. But it is still very heavily focused in sentencing that each sentence is unique. Prior sentences, again, it's similar sentences for similar offenders in similar circumstances. So similar doesn't mean the same. So so each case is still unique, but you have some guidelines. Again, because I think it's only fair that, and people need to be able to know, have some general idea of what the consequences might be. I think that's, again, only fair for people to at least have a general understanding of what their jeopardy might be in any given case. Because how can you decide whether to take a plea bargain or whether to go to trial if you have no idea whether the sentence you've been offered is what you might get? So So we have a question about on bail conditions. Tamara Litch had conditions to not contact people who are not victims or co-accused, and were friends of hers. Well, I don't know. That sounds strange. Usually you can only be limited from contacting co-accused, witnesses, complainants, victims. So I'm not sure about the particular circumstance of her case, on what basis various no contact orders were justified. I mean, they do need to be justified. There's no blanket, you automatically get to have a no contact. I don't know whether she agreed to them. Unfortunately, a lot of people, out of expedience, they agree to bail terms that are not lawful because they don't want to wait an extra day or two to have a bail hearing. They want to get out. Or they might be advised, well, look, we've got a guaranteed release if you agree to this, or we roll the dice at a bail hearing, and you'll probably get out, but I can't guarantee it. And sometimes people say, well, I guess I'll just take the sure thing and I'll agree to those terms, even though they're probably not right and they probably wouldn't be upheld. You could always have an option of a bail review. I don't know whether that was pursued. You'd have to ask her lawyer. I mean, he'd have to have a release from her to discuss it. But there's just too many unknowns to really give a firm answer to that. And as to why Ben Dichter and Tom Marazzo were never charged, that is a fantastic question. That's a question for law enforcement. I actually don't even know who Tom Marazzo is, so maybe it's not as egregious that he wasn't charged. As for how Ben Dichter wasn't charged, well, let me just say, maybe look a bit into his background, and maybe you'll see a few hints of perhaps why he didn't get charged. I suspect that there's maybe some, shall we say, demographic reasons why he wasn't charged. Oh, well, and also the fact that he bailed on the Freedom Convoy very shortly before. I think he said he broke his foot or something. Because I know he's given a bunch of interviews afterwards. I think I saw an interview where he said, yeah, he broke his foot, so that's why he wasn't there. So partly it was that he happened to not be there right at the right time. Maybe that's coincidence, I don't know. But yeah, maybe have a look into Ben Dichter's background and some of the different groups he's been involved in, and you may come to your own conclusions of maybe possibly why he wasn't charged. So okay, so the indication here in the chat is that there was a bail review on there was a bail review for Ms. Litch, and those no contact terms weren't raised. So I mean, if they weren't raised, she wasn't challenging them, so I guess she was okay with them. I mean, there can be unlawful things, but if no one challenges them, then they stay in place. There's no automatic that the terms just get taken away if they're not lawful. You have to actually challenge it. So, similar to unlawful laws, like what we were talking about earlier in the show, where we were talking about the mandatory breathalyzers without any suspicion of anything. My view is that's unlawful, but nothing is going to change. Like, it's going to stay on the books until it gets challenged. And the way it could be challenged is if someone wanted to bankroll it, they could hire a lawyer to just file a constitutional challenge at the federal court, but no one's done that. So the way it will likely be challenged now is someone somewhere will pick up an impaired driving charge or an over 80 charge as a result of one of those mandatory breathalyzers, and then they'll challenge it in court. And they'll say that I should be found not guilty because the law that I was charged under is unconstitutional. So I'm gonna be ending this soon. I love the interaction, lots of questions. That's great. So that's encouraging me to do this again in the not too distant future. Maybe we'll do it once a month. Although we'll have to change what day of the week I do it, because Wednesdays are not a great day for me to do live. We'd have to do another day of the week, so I'd be interested in people's thoughts. I would put up a poll, but I'm going to spend too much time typing to put up that poll right now. I think we can put up a poll that's not live, just regularly on the channel, so maybe we'll do that, of what day of the week people would be interested if maybe we did a monthly live chat. So before I get to the question that Richard reposted from Linda, what happens if you refuse to do the breathalyzer? You will be charged with refused breathalyzer, which carries with it the same, actually a harsher penalty than if you blow and fail. Well, if you blow and fail and you blow between 80 and 100. Off the top of my head, I haven't done a refusal trial recently, so I believe it's a $2,000 minimum fine. And when you're driving prohibition for refuse, and in Ontario at least, they won't give you access to the early ignition interlock program, where you can have an exception to your driving prohibition after 3 months. So I would not recommend refusing a breathalyzer ever. Blow, and then a lawyer has much more to work with to defend you. If you refuse to blow, it's so hard to defend. It's much harder to defend, because then all they need to prove is that you refused. Now, you can still challenge the lawfulness of the demand, but you can do that if you blow as well. So I always blow when they give you the demand. Don't ever refuse. That would be my recommendation. So Linda asked, with all the new bills being passed by our current federal government, which one is most concerning, and with the new government, could they be reversed? I'll answer the second part of that question first. Any bill can be reversed by a future government. I mean, the fact that it was put into legislation through Parliament, new legislation can be put into Parliament that undoes it. So that can easily be undone. But the Uniparty isn't going to do that, in my view. I think people are putting a lot of hope and a lot of stock into Pierre Poilievre and the Conservative Party of Canada. They'll change a few things, but the most important things, I don't think they'll change. In terms of new bills being passed that are most concerning, it would be hard for me to say one particular bill off the top of my head that is the most concerning. There's a number that are concerning. maybe I'll do an episode on that. I'll sit down and have a look at what was passed when, what had been passed in this most recent parliament. But I think what's a bigger concern is a lot of regulations that don't even have to go through Parliament. That's where a lot of the really concerning stuff comes in. I mean, like the regulation that banned AR-15s and hundreds of other lawfully owned firearms at the stroke of a pen. That's highly concerning, and that could be just as easily undone by a quick stroke of the pen by Prime Minister Poilievre. I'm quite certain he'll be the Prime Minister by I guess December, late November of 2025. So things like that could be quickly undone. Immigration policies, I think everyone can see the impact of the immigration policies. And I say policies because a lot of them, it's not even law, it's just policies. Yeah, Richard's reminded me of a good one. The online harms bill. We talked about that in episode 195. That's a big one. That's one that I'd like to see reversed, and that's one that won't be reversed because the Conservatives, I'm not sure that that's one they actually voted in favor of, but they didn't put up much of a fight. I know that the so-called Conservatives, they fully supported. There was unanimous support for the bill that the conversion therapy bill. That's a hugely problematic one. That bill, as I've argued, renders Christianity illegal and renders Islam illegal as well. But we know they don't need to fear. They're not going to be charged for teaching their children that they don't believe in homosexuality in their religion. But that one's hugely problematic, and it was unanimously voted by Parliament. So every single member of the Conservative Party as well voted in favor of that. So that one's not going anywhere. Online harms bill, they did put up a bit of a fight on that. Maybe that'll go somewhere. So maybe those two would be two of the ones that would be highly concerning. So thanks for your appreciation, Kimberly Jane, saying we're in a time where every level of professional holds too many corrupt or at least willing to join in instead of speak out. So that's why you appreciate me. So I appreciate you appreciating me. We are in a time where there's a lot of very concerning things. But if you look through history, unfortunately, throughout history, it's always the vast majority of people aren't willing to speak out. But as I've also said in previous episodes, I've looked at how did we get here. I think now a lot of people may disagree with me on this, but my view is that number one reason why things are the way they are is because people have turned their back on God. The society as a whole has, and certainly like individual people, by and large, have turned their backs on God. So without that support from the most powerful, by far, omnipotent, omniscient individual, without that support, you can't. How can you expect a country to stand? Have a look at episode 84. That's where I talked about that. So have a look at episode 84. Running Man asked, "Is farting on people, could that be considered an assault?" Might be. I represented someone who was charged with assault for allegedly coughing on someone. Of course, when you actually watch the surveillance video, he coughed into his hand away from the person. But this was a COVID. Things were so insane during COVID, and that was one of these hero LCBO employees who are so downtrodden and who are on strike right now. One of them called 911 because a client of mine had the audacity to accidentally cough once in an LCBO. And again, you could see the surveillance video. He turned away from her and coughed into his hand. And 911, he was charged with assault. Now, fortunately, some reason prevailed, and that charge was withdrawn. I was supremely disappointed that the police laid that charge, but everything was insane. Everything was insane at the beginning of COVID. I think that was fairly early COVID. So anyway, that's about all we've got. Just the last question from Tao is used. Now that the U.S. has dealt with the Chevron defense, are there any movements in Canadian courts to do away with deference to quasi-judicial organizations? Not that I'm aware of, but that's not really an area I work in. I probably something like the Justice Center for Constitutional Freedoms. They might be good people to ask if there's anything in the works for that in Canada. Although I'm not very familiar with all of the that Chevron defense. I've heard of it, but just haven't had time to really look into it. So. We're getting close to an hour. I was only planning on doing this for half an hour, so I'm gonna call it quits here. I need to go home at some point, and I've been in court every day for the last 2 weeks. I haven't been home before 9, so I think my wife and children would like to see me. So thank you for everyone that did tune in. We had pretty good numbers. Honestly, I'm surprised. We had almost twice as many viewers at any given time than we had when Mr. Bernier was on here. Which maybe not the greatest sign for the People's Party of Canada, but thanks for the final comment there from Kazee, calling me Chad's butter. That commenter, under his tutelage, I've been trying to bulk up a little bit this summer. So I guess it's working, is what he's saying. So. Thank you for your learned instruction on that. I know law. He knows how to get jacked. So we've made a little bit of progress, I guess, in that regard. So thanks for that, and thanks again for everyone tuning in. And have a great week. And yeah, we'll put up a poll soon to see what might be a good day of the week to do a live. Just, maybe once a month, just kind of switch things up. It's interesting, and frankly, it's a lot less preparation for me than a regular episode. So I would enjoy doing that. So thanks again, everyone, for tuning in. And remember, don't talk to police. This episode is not individual legal advice. We've talked about some generalized legal advice, but it's not specific advice that you should rely on. Always call a lawyer to get advice that's tailored to the specifics of your situation. Again, we've come up with a few show ideas in here. Please email us, share them in comments boxes if you have other ideas, and spread the word. We're still struggling to get to 10,000 followers on YouTube, and that'll open up some more options for live streams and things like that. So please like, share, and subscribe if you found this episode at all interesting, helpful, informative. And thanks again.